Hi guys, my name is Kuntinavas A. If you're new to the channel, please kindly subscribe. Today I'm going to be doing the fourth assignment of HFL 1501, Historical Foundations of South African Law. So this is actually a quiz assignment. So yeah guys, as you can see by the screen, you have 2 hours to complete this assignment. So I've just recently answered my questions. So I'm just gonna be reviewing the questions they may ask you on your assignment and how you could actually get good marks on before attempting the quiz, guys. So yeah, if you're new to the channel, kindly subscribe for future content. And without actually wasting time, let's quickly go throughout the questions you may be asked in your assignment, and hopefully you get like 80% for these, guys, because it's actually easy. So the first question says that in which of the following decisions did the Constitutional Court in minority judgment state that granting the applicant's request would not unfairly impact on the owner's use and employment of his property? So you have several options, and Bayron and others v. Clientele, PDY, Port Elizabeth Municipal. You have occupants of Evan, and you have Daniels v. Sabrin Bryant, what. So the first answer for me is Baron and others v. Clientele Limited and other. So that was actually my answer for this question, which says that which of the following decisions did the Constitutional Court in a minority judgment state that the granting of applicant's request would not unfairly impact on the owner's use and employment of his property? So next question, let's go and see. Next question reads as follows, guys. So let's just wait for this. Next question says that which of the following statements does not reflect on one of the points of criticism raised against the Constitutional Court's decision in the case of Baron and others v. Clientele? So this is a case that I chose on my previous answer, right? So my answer to that was actually this one. I don't know why I chose the last one. The courts did not sufficiently consider the rights of the occupants who lived on the farm before they were employed there. So that was my answer for that case. You basically have to go throughout your study guide and look at that specific case. Then you'll understand why I chose this one. Next question. So which of the following is a valid example of original mode of acquisition of ownership? So yeah, you have to basically look at these terms in Latin and convert them in English, right? So which one of the following is a valid example of an original mode of acquisition of ownership? So for me, I kind of like said res in commensiam, so which means that things inside the commas. So yeah guys, for me that was the correct answer. Then I moved forward, and question 4. So guys, which one of the following statements regarding the protection of ownership is not correct? So which one is not correct in regards to the protection of ownership? So I chose which one did I choose? I kind of like chose the last option, because these other ones, they did make like they are understandable, guys. So you basically have to find out which one does not fall under the protection of ownership. So obviously, as an owner of a certain item, I have to protect my assets, right? So you basically have to make sure that if somebody steals your item, that you still have a legal action against them, right? So the last one says that is an example of a personal action. So yes, it is an example of a personal action, but is not uh, required on a legal perspective. So that's what I said. So moving on. So indicate whether the following statement is true or false. So non-consum a non-consumable thing is not consumed by its normal use. So okay guys, a non-consumable thing. So obviously is something that cannot be consumed as in like to be eaten or used, right? So it says that a non-consumable thing is not consumed by its normal use. So in reality, there's no such thing as a non-consumable thing, guys. So for me, I kind of feel as if it is false. I mean, everything it can be used or can be eaten. So I could make an example. Food does not fall under this category because a food is actually a consumable thing. So a non-consumable thing in terms of the law is actually kind of tricky, but but most things you are usable, guys. So for me it's kind of like straightforward. I said false. Moving on, which one of the following statements regarding trans- transformative constitutionalism is not correct? So for me, I said that the South African Police Service and Public Protector ensures that the implementation of transformative constitutionalism. So the South African Police Service and the Public Protector ensures that the implementation of transformative constitutionalism. So as for me, I said that was the correct answer, but you could choose between these options as well. But yeah. Question 7. Identify whether the following statement is true or false. The two actions applicable in disputes involving servitudes are the actitio confessoria and the actitio negatoria. So you have to basically search those terms in English, then you'll understand why I said true. Because you basically have a plaintiff who argues that somebody is wrong on a legal perspective, then you have a defendant defending their case. So for me, I said true. Question 8. So question 8. Question 8 says that which one of the following things was not regarded as a thing outside commerce? So under ancient Roman law. So which one was not regarded as a thing outside the commerce under ancient Roman law? So you basically have to go throughout your study guide. Let me see on which specific page you may find this answer, guys. So if you go to page 75, you will find the examples, and the one that was not mentioned under those examples was a private road. So basically, under ancient Roman law, a beach, a temple dedicated to Mars, sports stadium. These are facility. I would so claim these are the things that are under the government, right? So a private road is not owned by the government. So that's why I said that it does not fall under ancient Roman law, because ancient Roman law mostly specialized on public buildings, public, basically everything that is public, like public infrastructures as well. So yeah, that's why I say private road. Next question. Next question says that which one of the following statements regarding real securities is not correct? So the correct answer for me, I said that agreements related to real securities traditional involve debtor and creditor as parties without the involvement of any third parties. So obviously when you are making like some sort of contract or arrangements or whatnot, so you know, even if you are getting married, like there has to be a witness, right? There has to be at least three parties to witness that. Like, so yeah, for me I kind of felt like there has to be a witness if you are doing something, if you're negotiating something with another person. So yeah, that's my take on that. The last question, okay, says that which of the following statements does not express the consequence of the requirement that a unsuffract has to be exercised? Salva reram substantia, keeping the substance of the thing intact. So for me, I said that the unsatisfactual was not allowed to change the nature of the thing. So yeah, guys, that's what I said on the last question. And when I press submit, these are my answers. So guys, let's see what happens once you submit. Your answers won't be able to change. Da, 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 da. So guys, the purpose of the video is to show you the questions you may be asked on your assignments, and I've actually written down this assignment before, but yeah guys, hopefully you get good marks for this. Let me see how much I got. So guys, as you can see, I've gotten 15 out of 25.